Hi friends, good morning. Yes, so in continuing with our discussion on the Constitution, today's agenda is from Article 40 to 49, again dealing with directive principles of state policy. So as we saw the other day, the Constitution has split the jurisdiction of mandating laws between the center, state, and concurrent lists. In which scenario? I'm sorry, some disturbance. Yes. Uh, the directive principles of state policy are more guiding factors based on which the states are required to make up their policy for administration. Thanking Deepika and Jugal for their efforts to get the work for us done today. These are some of the terms. I think most of it, or rather all of these, are fairly rudimentary and which we have seen as well in the past conversations. The schema would be about, you would be able to relate a lot to the way our society or the state level activities are structured. So it talks about organization of panchayats, provision for human conditions of work, humane conditions of work, minimum wages, living wage for workers, public health, child care, labor management, uniform civil code, another area of a lot of debate and discussion going on. Agriculture and animal husbandry, protection of environment and wildlife, and protection of monuments and places of national importance or eminence. So these are the various articles which we would be dealing in today. Organization of village panchayats, Article 40, right to work, education and public assistance in specific circumstances, 41, provision for humane conditions of work and maternity leave, 42, living wage, etc. for workers, 43, participation of workers in management, 43A, uniform civil code, 44, provision for free and compulsory education for children, 45, promotion of educational and economic interests of scheduled castes and tribes and other weaker sections, 46, duty of the state to raise the level of nutrition and the standard of living and to improve public health, 47, organization of agriculture and animal husbandry, protection and improvement of environment and safeguarding of forests and wildlife, 48A, and monuments and places of importance, 49. Let's quickly look at each of these in some detail. Moving on to village panchayats. So, organization of village panchayats, if you notice, you have the cities, towns, villages, districts, and it moves on because given the size of the country and diversity. So, the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self governance. So, if you notice, friends, given the diversity of our country and the uniqueness with which each of these societies, smaller societies, are organized, they have a lot of things which are unique to their own small community or tribe or locality, as we may call it. So, which is why village panchayats have been created to decentralize a lot of the roles and responsibilities of administration by the states. So, though Panchayat Raj institutions have been in existence for quite some time, it's been observed that these institutions have not been able to acquire the status and dignity of viable and responsive people's body. So, primarily, you would notice the chief of Panchayat would be a body which is managed or dominated by the local chieftains. So, there are many reasons why they were not able to get the respect or relevance of a state body, which include primarily being absence of regular elections, insufficient representation of weaker sections like scheduled castes, scheduled tribes, and women, inadequate devolution of powers, and lack of financial resources. So, the severe lack of representation by the weaker sections is one of the fundamental reasons why the Panchayat Raj has always been criticized. So, hence, it was felt that there is a need for upliftment of these communities by providing them with reservations in the Panchayat institutions, so which in turn enable the idea of participative democracy, where all sections of society are represented. And therefore, it was felt that there is a need to enshrine in the constitution certain basic and essential features of Panchayat Raj institutions to impart certainty, continuity, and strength to them, which was done by the 73rd Amendment to the Constitution. So, what was this amendment about? So it was to introduce a new part relating to panchayats in the constitution, which focused on the constitution of panchayats at a village, direct elections to all seats in panchayats at a village and at the intermediate level, appointment of chairpersons of panchayats at such level, reservation of seats for scheduled castes and tribes and women, fixing a tenure of 5 years for panchayats and holding elections within a period of 6 months in the event of suppression of any panchayats, disqualification for memberships of panchayats, sound finance of the panchayats by securing authorization from state legislatures for grants in aid to the panchayats from the consolidated fund of the state. So over a period of time, as our society evolved from 1947 to 1973, we felt that it made sense to empower panchayats because it is humanly impossible to expect people in Delhi or at the capitals of state to be able to monitor and execute the public requirements at the panchayat or the village level. Next, right to work, education, and public assistance. So, the state, which is again related to the fact that labor laws by and large are dominated by state governments. So, the state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. So, social and economic justice is one of the goals which was set out in our preamble, and Article 41 sets out certain goals like securing right to work, education, as well as providing public assistance within the ambit of the fundamental principles of state policy. Again, we need to understand, friends, India is a welfare state. So, therefore, moment you consider a society as a welfare state, it needs to provide a large number of social services like public health, national health, unemployment insurance, widows and orphans pension, old age pension, public assistance, etc. So this is further we've had certain enabling regulations like the Factories Act, the Workmen's Compensation Act, as well as legislation restricting the employment of children under a certain age for hazardous jobs. Similarly, provision for just and humane conditions of work and maternity relief, Article 42. The state shall make provision for securing just and humane conditions of work and for maternity relief. And it was made consequent to this article and the enabling regulations. It was made mandatory for most establishments to offer maternity benefits to women employees. And maternity benefit in India was mainly governed by the Maternity Benefit Act 1961, which applies to all shops and establishments with 10 or more employees. The Maternity Benefit Act provides that a woman will be paid maternity benefit at the rate of her average daily wage in the 3 months preceding her maternity leave. The law also allows employers to permit women employees to work from home, and an employer cannot dismiss a woman for taking maternity leave and cannot serve a termination notice to a woman on maternity leave which expires before the maternity ends. Laws for labor force. So we've got quite a good number of regulations governing the welfare of labor in India. So to give you a perspective, Industrial Dispute Act, Contract Labor Act, the Weekly Holidays Act, Mines Act, Motor Transport Workers Act, Hours of Shift Work, Spread Over Rests and Overtime, BD and Cigar Workers Act, Factories Act. So you could see that different regulations which have been enacted in certain cases specific to certain industries to address the specific occupational hazards and requirements of people working in that industry. So living wage, etc. for workers, again Article 43. So the state shall endeavor to secure by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial or otherwise, work, a living wage, conditions of work, ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities. And in particular, the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. So typically, we are talking about a case where the constitution mandates a state to bring in regulations to ensure that the workers have a reasonable wage criterion. The conditions of work are something which can otherwise be considered respectable for any human being. And more importantly, there is an element of leisure and social and cultural opportunities for laborers. So this is where, even from an economic standpoint, when we look at India, we always say India is a mixed economy. Basically, because we have the principles of both a socialist state as well as a capitalist economy, where on one side we say that the industry should be free to operate, free from government intervention, and everyone has a right to do business in this country. But the fact that they will be allowed to do with certain principles of respecting the dignity and livelihood of employees makes it a classic case of a mixed economy. And the fact that all these are enshrined in the constitution makes it a lot more onerous on the institutions, various public institutions, to make it a matter of state policy. Participation of workers in management of industries. The state shall take steps by suitable legislation or in any other way to secure the participation of workers in the management of undertakings, establishments, or other organizations engaged in any industry. So, workers' participation is essential, which is why you see that workers being part of the labor compensation board. In the case of the Gujarat Kamdar Sahakari Mandal versus Ramakrishna Mills, it was held that Article 43A intends to herald industrial democracy and marks the end of industrial bonded labor, which is something India has always propounded post the independence era. And the rationale very clearly behind Article 43A is the fact that management of enterprises should not be left entirely in the hands of capitalists, and that the workers should also be entitled to participate in it. The workers have a special place in a socialist pattern of society, and which is the reason why trade unions and other associations are promoted and even sanctioned by legislations like Trade Unions Act 1926. Uniform Civil Code, an area of very, very high elements of debate. The state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. UCC, as we call it otherwise, is currently an ongoing area of debate regarding the Indian Constitution's mandate to replace personal laws based on scriptures and customs of each major religious community with a common set of rules governing every citizen. Article 44 directs the state to apply these principles while formulating policies for the country. It's become one of the most controversial topics of current era, especially given the fact that the largest ruling party has made this as one of its election agendas, or it's part of the election mandate. So, what is it the high level points around this? UCC is considered to be fostering national integration, where all citizens would be regarded as equal, and everyone shall have same rights and privileges irrespective of their personal laws, and therefore there will be no scope for politicization of issues of discrimination or concessions. Whereas the argument against UCC is the fact that India is a very diverse country, and UCC violates or robs the nation of its diversity, or violates a fundamental right to practice a religion, which again is part of the Constitution under Article 25. And fact that they hold that a state action to introduce UCC is against the quintessence of democracy. The secular state is an enabler of rights rather than an inhibitor in sensitive matters of religion and personal law. So this is the other school of thought. Only time will tell which aspect of debate holds good in the long run. Just to look at a couple of interesting decisions in this regard, in Shabnam Hashmi versus Union of India, the Apex Court observed that the rationale behind Article 44 is that personal beliefs and faith should not dictate the laws applicable to persons, and emphasized on the need of UCC. Similarly, in the case of Lily Thomas versus Union of India, the Supreme Court held that it did not have any powers to issue directions for the codification of personal laws into a UCC, as the directive principles of state policy are non-justiciable. This is something which we saw in the other case as well in the last week webinar, that directive principles are only guidances and they are non-justiciable. Childhood care and education. Provision for early childhood care and education to children, Article 45. The state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. So, which has made it mandatory for the state to provide play schools, kindergartens, and Montessori for kids up to 6 years. Further, the 86th Amendment of the Constitutional Amendment Act 2002 introduced right to education as a fundamental right under Article 21A, which provides free and compulsory education until the age of 14. So, till up to 9th or 10th standard, a child shall have access to free education. The right of children to free and compulsory education to Act 2009 was enacted in pursuance to the spirit of this article, so which is popularly called as RTE in this country. If we were to look at some of the relevant judicial proceedings, Supreme Court held in the case of Unni Krishna of the state of AP, held that RTE up to 14 years is a fundamental right within the meaning of Article 21. And it further observed that Article 45 deals with early childhood care and education below 6 years. And therefore, it noted that even though Article 45 is non-justiciable, the fundamental right under 21A covers within its scope the aims sought to be achieved by 45. So, sum and substance, your right to free education can be enforced constitutionally. It's a constitutional right. Promotion of educational and economic interest, Article 46. The state shall promote with special care the educational and economic interest of the weaker section of the people, and in particular of the scheduled castes and tribes, and shall protect them from social injustice and all forms of exploitation. So, because traditionally the scheduled castes and tribes have been considered as the disadvantaged groups, and for a nation to progress, all sections of its population need to prosper. We discussed the American budget yesterday, where we saw that there was specific impetus being given on areas of education and livelihood of black people. You can compare the kind of civil atrocities on scheduled castes and tribes to what used to happen in America for the black people. So, which is why this particular article has been specifically enshrined in our constitution to promote the educational and economic interests of the weaker section of the society, and in particular the scheduled caste and scheduled tribe, and also to protect them from social injustice. Some of the other measures to promote their interests, Article 23 prohibits trafficking in human beings, begging and beggars, and other similar forms of forced labor. Similarly, Article 24 prohibits employment of children below the age of 14, and is also significant for scheduled tribe, as a substantial portion of child labor engaged in these jobs are from scheduled tribes. 243D provides for reservation of seats for scheduled tribes in Panchayats, House of the People 330, and Legislative Assemblies 332. Nutrition and agriculture. So it's a duty of the state to raise the level of nutrition. Article 47. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as amongst its primary duties, and in particular, the state shall endeavor to bring about prohibition of consumption, except for medicinal purposes, of intoxicating drinks and drugs which are injurious to health. So, the recent publication of Mr. Abhijit Banerjee, the gentleman who won the Nobel Prize for his work on the weaker section of society using a randomized control test. If you notice, the extent of calorie intake has a significant impact on the life of an individual throughout his entire period of existence. And higher the intake at an early stage ensures that the person grows up to be a healthy individual, possibilities of getting educated is very high, and in the long run becomes an asset. That person becomes an asset to the society. Conversely, when someone is not being taken care at a younger age, possibility of him thriving as he gets older is not very high. Which is why, scientifically as well, and of course morally and ethically, the state has a duty to improve the level of nutrition. And if you look at a state like Tamil Nadu, the case of Amma Canteen, where cooked food was served at 1, 2 rupees or 5 rupees, and where a person could survive with just 10 rupees per day, one of the best possible uh, ways of dispensing this particular objective. Similarly, the midday meal scheme, where the children were sent to school, who were sent to government schools, were served sumptuous food. So all these are great initiatives which effectively ensured that over a period of time, the quality of nutrition at the younger level, because that's where the formation happens, has improved consistently. Alcohol prohibition, it's a controversial, again, a very, very controversial provision, especially from the state where I come from, Tamil Nadu, because TASMAC, the Tamil Nadu marketing arm which distributes liquor, is by far one of the largest contributors to the state exchequer. However, we do have alcohol prohibition in states like Gujarat, thanks to our father of the nation being born from there, Nagaland, Bihar, Mizoram, and Lakshadweep. Now, in Kode distilleries was the state of Karnataka, it was held that Article 47 is one of the directive principles which is fundamental in the governance of the country, and the state has the power to completely prohibit the manufacture, sale, and distribution of potable liquor as a beverage. Barring these 4 or 5 states, all other Indian states and union territories permit the sale of alcohol. Look at a place like Pondicherry, the entire tourism business. For the entire tourism business, cheap alcohol is one of the biggest attractions there. So, organization of agriculture and animal husbandry. So, the state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines, and shall, in particular, take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. So, this is again another very, very controversial conversation. You would have seen that there are regulations to protect cows and not human beings, but still, India is one of the larger exporters of meat. We also export as well as import significant quantities of leather. Article 48 was enshrined primarily to boost the agrarian economy, thereby uplifting animal husbandry in rural villages. Consequent to which, many states have enacted laws to prohibit slaughter of cows, calves, other milch and draught cattle. Some of the legislations which have followed this, the Andhra Pradesh Prohibition of Cow Slaughter and Animal Preservation Act, the Bihar Preservation and Improvement of Animals Act, the Punjab Prohibition of Cow Slaughter Act 1955. However, in states of Arunachal Pradesh, Assam, Kerala, Mizoram, Meghalaya, Nagaland, Tripura, and West Bengal, there are no restrictions on cow slaughter and beef is consumed here, which clearly shows the diversity of our country and the cultural preferences of people from different regions. We've had plenty of cases. Just look at a couple of them. In the case of Mohammad Hanif Qureshi was a state of Bihar, and Abdul Hakim and others was a state of Bihar. The Honorable Supreme Court held that a total ban on cow slaughter was not possible if, under economic conditions, keeping useless bull or bullock be a burden on the society and therefore not in public interest. Similarly, in the case of state of Gujarat versus Modi Qureshi Kasab, so the Honorable Supreme Court interpreted Article 48 in consonance with 51A of the Constitution, being protection and improvement of natural environment, including forests, lakes, etc., and to have compassion for all living creatures, thereby justifying its decision on a complete ban on bovine slaughter. Moving on to the last leg, protecting environment and objects of national importance. So, Article 48A, in that protection of environment and safeguarding forests and wildlife, the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. So this article was introduced in 1976, consequent to the 42nd Amendment. And one of the serious man-made disasters was the Bhopal gas tragedy, which happened in 1984. Since then, the need for protecting the environment has become an important issue to concentrate on. This Article 48 is for the protection and importance of environment and safeguarding the forest and wildlife, and states are supposed to bring in regulations to follow the same. So to look at this Bhopal gas tragedy case, Union Carbide versus Union of India. The tragedy happened in 1984, one of the most heinous events in Indian history. The Bhopal disaster has brought in many legal questions on the responsibilities of transnational companies indulged in unsafe activities which have potential effects on the environment. In 1984, December 3rd, lethal and harmful chemicals were released from Union Carbide's manufacturer plant in Bhopal due to negligence, and it killed over 3,500 people and caused health complications in over 100,000 people. I think, if memory serves me right, there's a gentleman called Warren Henderson, who was the then CEO of Union Carbide, and he somehow managed to flee India when this happened and never returned back to the country, clearly knowing the fact that he could be arrested. The Bhopal Gas Leak Processing of Claims Act 1985 was enacted in the Parliament to make sure that the compensation was paid to the victims of the Bhopal gas tragedy. The Honorable Apex Court observed that more stringent laws with regard to environmental pollution and liabilities for environmental crimes need to be enacted consequent to 48A. Subsequent to which, various regulations have been in place. One was Environment Protection Act 1986, the Indian Forests Act and Amendment 1984, the Wildlife Protection Act Rules 1973, the Forest Conservation Act and Rules 1981, the Biological Diversity Act 2002, the Water Prevention and Control of Pollution Act 1974. So, last, protection of monuments and places of national importance, Article 49. It shall be the obligation of the state to protect every monument or place or object of artistic or historic interest, declared by or under law made by the Parliament to be of national importance, from spoliation, disfigurement, destruction, removal, disposal, or export, as the case may be. So the article mandates a state to protect artistic and historic monuments, places, or objects. In the case of MCA Constructions versus Archaeological Society of India, it was noted that Ancient Monuments Archaeological Sites Act 1958 and 51 were enacted pursuant to the mandate under 49. The Ancient Archaeological Monuments Act 1958 provided for the preservation of ancient and historical monuments and archaeological sites and remains of national importance for the regulation of archaeological excavations and for the protection of sculptures, carvings, and other objects. We need to understand, friends, India is a country which is so far not celebrated its history. If you travel anywhere across Europe or the Western world, there is so much of understanding of history, so much of correlation between or the link between their past and the present being established. Unfortunately, we've so far not considered the history, the historical relevance of various past events or our monuments in our daily lives. I think that aspect of our society is gradually changing. In Taj Mahal, in the case of Taj Mahal, MC Mehta versus Union of India, the Honorable Supreme Court issued directions that coal and coke-based industries in Taj Trapezium that were damaging the Taj ought to either undergo modification to gas or to be resettled outside the location. Supreme Court further directed that to safeguard the plants planted around Taj by the Forest Department. All these were done to promote again the life to expand the life of the Taj under Article 14. This was one of the main objectives of the state policy. So these were some of our thoughts on this particular article, friends. Hope to catch up with you again on another conversation of relevance. Thank you.